Bill, the matter of His Majesty's Revenue and Customs and URENCO.
I'm grateful, my lady. I appear with my learned friend, Mr. Waldegrave, for the Commissioners, and my learned friends, Mr. Peacock, King's Counsel, and Mr. Ripley, appear for the taxpayer, who I'll call URENCO. Please may I just start by checking that the court has skeletons on the appeal and cross-appeal from both sides, and the core and supplementary bundle, and then 4 files of authorities. I'm very grateful. You'll see, my lady, that we've got the shorthand writer is here, and I gather a transcript will be produced and will be available for today, tomorrow morning, and so on.
Very good. That's very helpful.
Shortly after. On the timing and the timetable, you will have seen that there is an appeal and a cross appeal. Learned friend and I have agreed that we'll simply take it that I will open on the revenues appeal. Learned friend will respond on that appeal and open his cross appeal. I'll reply on the appeal and respond on the cross appeal, and then any reply from my learned friend on the cross appeal, likely to be short. So I hope that's a convenient way of dealing with the various issues. We weren't absolutely in agreement about the timing. I thought I might need rather longer for opening, that it might take until around 3:15 today for that. We'll see how we get on. I've got no concerns about the overall time estimate, and inevitably it'll no doubt be affected by such questions as the court has for the two of us as we go along.
Yes.
in any event. So in terms of the running order for the revenues appeal, what I was proposing to do is to take the skeletons as read and then develop my oral submissions in 3 broad chapters. First of all, to deal briefly with the disputed items. Secondly, to look at the legislation and some of the legal principles. And then thirdly, to deal in turn with the grounds of the revenues appeal. And so to deal first with the question of Section 21 and the concept of building, then ground 2, plant and premises, and then ground 3, and which is rather shorter, the point on the provision of. So that's the running order for the appeal. And so, with the court's permission, before turning to the legislation, if I may just make a few brief points about the disputed items. We deal with those in the skeleton in the discussion of the factual background that's at paragraphs 5 to 11 of the revenues main skeleton argument. You'll have seen, my lady, that the expenditure that's in dispute, it relates to certain aspects, is probably the best way of putting it, of 5 facilities at what's called the Tails Management Facility at Capenhurst. That was a very big project. The total expenditure was some £1 billion, and we're arguing about around 192 million of that expenditure. As for the rest, there's agreement as to a large number of elements that do qualify for capital allowances, also agreement about a large number of elements that do not qualify. What we're left with is the balance where the parties have not been able to agree treatment. And those 5 facilities, you'll have seen from the 2 decisions, they were the cylinder handling facility, the vaporisation facility, the kiln facility, condenser facility, and the uranium oxide store. You'll also have seen that the first tier had the benefit of a site visit. It had detailed documentary and witness evidence before it. Helpfully, one of the things that the first tier did, and the upper tribunal repeated this exercise, was to append what were called block diagrams of each of the facilities at the back of the decision. So you'll get those in, it's bundled page 252. The first tier's decision, at least in my copy, isn't individually paginated, but bundled page 252. The upper tribunal has reproduced those, although it's formatted them slightly differently, so they appear, I think, on a different number of pages, but I think I'm right in saying that they're the same diagrams. And those are helpful in identifying the component parts of what it is that we're talking about when we look at the decisions. It's, of course, important to bear in mind when you look at those diagrams and indeed the discussion of the items, to bear in mind the first tier's finding that many of those items which are identified individually on the block diagrams were actually to be considered together for the purposes of the capital allowances analysis. That, of course, was the result of the first tier's findings in paragraph 72 of its decision, which is bundled page 234, because there was argument, at least before the first tier, about the level of identity of the various assets. What level should the inquiry be pitched at? Should you be looking at it item by item on an especially granular level? Should you look facility by facility? Should you do something in between? And you'll have seen from paragraph 72 that it was a somewhat in-between approach that the FTT had determined was correct. It looked essentially at the physical structure of each facility, looking at the physical structure of each facility as a whole. But then there were various exceptions. For example, there were internal shield walls, there were some raised platforms, there were plinths, certain stairs and access hatches. What the FTT said was that those items had retained a separate identity, and so they were to be looked at individually for the purposes of the capital allowances analysis. Now, there was no challenge to that finding about the extent of each asset for those purposes, and so that's the starting point. So the object of scrutiny is what the FTT found in paragraph 72. Just to give a little bit of context, if one has the supplementary bundle, there's a plan of the site at page 51 within tab 2. I simply show you that because it helpfully shows where the things are, where they are in relation to one another. It's a scale plan, and you can see the various items are labelled. So, for example, top left, the cylinder handling facility, and then across from that, the uranium oxide store. There was a similar plan actually used for the purposes of the site visit, which is at page 58, which I hope you have in a slightly bigger format in A3. I hope that's made it into the court's bundles. If it hasn't, we can supply you with copies. But it's a similar plan. What it does...
I don't have it in A3.
Oh,
nor do I.
I can have that handed out. The print on the original one wasn't very good. We thought it had gone in. I'm sorry that it...
Yes, it's well nigh illegible in its
yes.
current format.
What...
Thank you very much.
I'm not going to take lots of time addressing you on plans or anything else. This is simply for context and so that you can see when you read the decisions where the things are. And this was what the first year in the parties actually had for the tour that took place, 14th of September 2018. The tour actually took place before the hearing. The reason for that was because the facility was about to go live, and once it went live, access to a number of the facilities would be restricted. So they're the two plans. It also shows, and this is my point about the 192 versus the 1 billion, it shows you the other elements of the site as well. We don't obviously need to worry about those, but you can see there's more going on at the site than just the 5 facilities.
Do we have a photograph anywhere of just how the thing looks?
Yes, I was just going to do that next. Just having prefaced it by saying that the FTT did make observations about how the thing looks, both in its detailed discussion of the items, and I'll look at that when we get to the grounds of appeal. At this stage, I was just going to note, before showing you the photograph, paragraph 39 in the decision, bundle page 228, the FTT noting that from the outside, the various facilities comprising the TMF, that's the Tails Management Facility, give the appearance of a single modern industrial type building, albeit with different roof heights. And then going on to say that the cylinder handling facility and the uranium oxide store give the appearance of being large warehouse type structures. And if we just stay with the supplementary bundle, I can show you that by reference to a couple of photographs. If I start with 3 external ones at page 108 within tab 5, first of these may be a computer-aided one, but nothing, I don't think, turns on that. But 108 is the outside of the cylinder handling facility, if the court has that. (109) is the 3 elements that made up what was called the tails deconversion plant. So that's the vaporisation facility on the left, the kiln facility, middle right, and then the condenser facility on the right. And then over the page, you've got 2 photographs of the outside of the uranium oxide store. Now, all of those facilities, they were of considerable size and a solid construction. And we summarise the relevant findings at paragraph 9 in the skeleton. And so just by way of example, the photograph that you see of the cylinder handling facility, it is 16 metres high. It's covering an area of just over 3,000 square metres. And it had a reinforced concrete shield roof, reinforced internal and external concrete shield walls, and a reinforced concrete raft slab. You'll see in the decisions a lot of reference to raft slabs. The court will probably know this anyway, so it's a type of foundation, effectively. It's what the building sits upon. And those points you can see for the cylinder handling facility within FTT para 41. And then, again, just to illustrate, the uranium oxide store, it was rather bigger in terms of area, so it was 6,700 square metres. I think that's just under a football pitch. And the walls were 10 metres high. So the FTT, it had those photographs, it had the site visit, it had numerous other diagrams and photographs as well. There is a selection in the supplementary bundle. I'm not going to take up time with them, but just to give you a flavour of what there was, and in case it is useful to look at them at any stage, just so we know where they are. The various plans are within tab 2. So these are exhibits to Mr. Nicholson's witness statement. And at page 54 to 56, you can see plans of the cylinder handling facility, the tails deconversion plant. And again, you see there the vaporisation facility on the left, kiln facility in the middle, condenser facility on the right. And then the uranium oxide store, page 56, with its various modules. And within tab 4 of the supplementary bundle, there are further plans and computer-aided drawings. That's 59 to 66. I wasn't proposing to take you through those. There are also further photographs of each of the facilities. These are mostly internal. Earlier in supplementary bundle tab 5, and again these were before the FTT. You can see from page 69, it was Mr. Nicholson who gave evidence and was cross-examined. He produced those. And just by way of example, if the court has supplementary bundle page 71, figure 2, you can see the inside of the cylinder handling facility, and you can see in sort of bright yellow and then an orangey colour on the left and halfway up, those are the stairs and the access platforms that are discussed. And then effectively overhead in orange, and then with some red, that's the crane that gets talked about a bit in the decisions. And again, just by way of example, if one goes on to page 102, C5, figure 44, that's one of the interior photographs of the uranium oxide storage. So you can see the external wall, the internal wall. You can see the crane up on the top left, and you can see the inside of the roof. Just for completeness, behind tab 6, there are some photos which I think Learner Friend wanted in. These are from the exhibits of a different witness, a Mr. Banner. Mr. Banner was dealing with the manner in which the facilities were constructed. And so if one turns through the photographs within tab 6, I'm not going to take time over this, but I think I'm right in saying that what you will see is the facilities at various different points during their construction. So that's a slightly different perspective. I'm not going to say anything more about those photos at this stage, but my friend wanted them in, and if he does go to them in his submissions, I may come back to them in reply. So I hope that's helpful by way of context for what we're arguing about. It is those items identified by the first tier at paragraph 72. And as we'll see, as the dispute has evolved, what we're principally interested in are the items that comprise the structure of the facilities. There are points about stairs, plinths, access platforms, and the like, but in the main, what the dispute is focusing on is that physical structure of the premise of the facilities. And there obviously are issues of terminology and language, because we've got issues about are these plant, are these premises, are they buildings, are they, as Milena Friend says, structures. Inevitably, I may lapse into saying it's the premises, it's a building. Part of my case is that ordinarily that's how one would characterize these things. What I'll try to do is use a neutral word and call them facilities, so far as I can remember to do so, and I hope that's helpful. I should also just note that what we're not arguing about in this litigation is each individual item of equipment that may lie within each of the facilities. So just to give you one example, there were autoclaves in the vaporization facility. It's common ground that those get plant and machinery allowances. We're not arguing about them, or at least not arguing about them directly. There is that issue under ground 3 on the provision of about pipe work, where Milena Friend tries to say, oh, well, parasitically, the walls and the slab in the vaporization facility were part of making plant work. So we get into equipment a little bit under ground 3, but in the main, one must bear in mind that we are not arguing about the kit within each of the facilities, and equally, it is not the case, because this is not what the first tier found when it came to paragraph 72, that the facilities and the kit within them together form one complete whole. That wasn't the basis for the analysis. It was the items that are identified in paragraph 72 that have to be looked at separately from the particular items of machinery or equipment that was placed within them. Now, if one looks at paragraph 26 in the first tier's decision, you can see that the first tier labelled the facilities safety significant structures. And broadly, they were designed with 3 main purposes in mind, as the FTT recognised: providing radiation shielding, that was blocking the path of radiation; providing containment, and what was meant by that was the prevention of the release of radiation particles, so keeping radiation particles within the facility; And then the third thing was what was called seismic qualification. And essentially what that was doing was making sure that machinery, equipment, various structures would continue to operate properly, very broadly, even if there was, for example, a 1 in 10,000 year earthquake at the site. So it had to be constructed to a level that were there such a level of seismic activity, the equipment would continue to function. And what the FTT did later in its decision was look at, in particular, those functions and also the other functions that were being performed, and it fed that analysis into its overall conclusion, both as to whether it was dealing with plant on the one hand, premises on the other, and also whether it was looking at a building or merely a structure that was not a building. So I hope, my lady, that assists with some of the factual background and what the items actually are. And I appreciate that there is an element of having to look both at the decision and then getting some more context from the photographs and the plans. But of course, what we're mainly interested in is the soundness now of the upper tribunal's decision, and specifically whether it was entitled to interfere with the decision of the first tier, and whether it was right as it considered appropriate to remit. And that follows from the analysis of the legislation and the principles that have been developed in relation to that legislation. So if I can go there next. Legislative background, just for your note, is summarised in paragraphs 12 to 23 of the skeleton, but please may I show you the main provisions in the original and then make a couple of observations about principles before I turn to the specific grounds of appeal. The general rule, as it's called, is in section 11, Capital Allowances Act 2001. That's in Authorities Volume 1, tab 5, page 21. And section 11 is within part 2 of the Act, which deals with plant and machinery allowances. And you can see that the title, General Conditions as to Availability of Plant and Machinery Allowances. And section 11 sub 1 tells you when allowances are available under this part. And so under this part, that's why we're talking about plant and machinery allowances, because that's part 2. The person has to carry on qualifying activity and incur qualifying expenditure. I don't need to take up any time with qualifying activity. It's common ground that there was a qualifying activity because URENCO was carrying on a trade. And for your note, if you want to, it's section 15 sub 1 sub A gives that requirement. There's no dispute about it. On qualifying expenditure, we get the general rule in section 11 sub 4. And so to be qualifying expenditure, the expenditure must be capital expenditure on the provision of plant and machinery, wholly or partly for the purposes of the qualifying activity carried on by the person incurring the expenditure. And then in little b, there's a further requirement about ownership. There's no difficulty with the little b requirement, common ground that URENCO owned the plant, so the little b requirement is satisfied. Also no difficulty with the expenditure being capital expenditure, common ground, it was indeed capital expenditure. Nor is there any difficulty with trade purpose, common ground that it was for a trade purpose. Question, however, is whether that capital expenditure was on the provision of plant or machinery. And I'll say a bit more about that general rule and what's been done with it in the case law in a moment, and also probably rather a lot more under ground 2, and because that general rule has been, that's what's generated the very considerable case law on the concept of plant. But if I just stick with the provisions themselves for now, if one goes on to section 11 sub 5, you see that that general rule is affected by other provisions of this Act, and in particular by Chapter 3. And part of Chapter 3 is sections 21 to 23, which we get behind tab 6, bundle page 23. Now, these were, at the time, new rules. They were originally enacted in Finance Act 1994, and they originally came in as amendments to the Capital Allowances Act 1990. There's an issue on the cross-appeal as to the extent to which it's permissible to look at the old law. So I'm not going to get into that for now, but I just note that that's when they came in Finance Act 1994. At the time that we're concerned with, the relevant law was in the 2001 Act, and Section 21 sub 1 specifies that for the purposes of this Act, expenditure on the provision of plant and machinery does not include expenditure on the provision of a building. We're then told in subsection 2 that the provision of a building includes its construction or acquisition. Section 21 sub 3 then gives us a partial definition, or at least an inclusive definition would be a fair description. That gives you various assets that are included in the concept of a building, but there's of course no definition of the core concept itself. 21 sub 3 little c links into list A, so you can see what's happening in 21 sub 3. These are things that either do not or at least might not answer to the ordinary description of a building, and so they're being brought in. And so list A headed up assets treated as buildings, and there are then very obvious things: walls, floors, ceilings, doors, and then certain other things, main services, sewerage systems, and the like. There is then a link as to what we'll see as an exception to the exclusion in section 23, and the link is in section 21 sub 4, where you see this section is subject to section 23. Section 22 over the page, bundle page 24, that deals with structures, assets, and other works. It's common ground in this case that section 22 is not applicable. The reason for that is that if these assets are found to be structures but not buildings, they would, on that footing, fall within the exception in list B, item 7, little a. So they would be, if they're structures but not buildings, they'd be structures. They're not listed in items 1 to 6. But they would come within the notion of industrial building in Chapter 2 of Part 3. Chapter 2 of Part 3 is part of the legislation dealing with industrial buildings allowances. They'd actually been repealed by the time of the accounting periods we're concerned with, but what you had was that if you had a structure which counted as an industrial building, because an industrial building included both buildings and structures, that definition was borrowed effectively for the purposes of list B, item 7, little a. And so if you had any industrial structure that's not a building, it's potentially within list B, item 7, little a. So neither party relies upon section 22 in and of itself, because it's common ground that it doesn't apply. And a friend, and you'll have seen the upper tribunal, they look to make something of the relationship between section 21 and section 22. So section 22 is relevant to the issues in this appeal, and I've got submissions to make about what the upper tribunal did in relation to its conclusions on that relationship. The other point, just before I leave section 22, and I will come back to this, is to note section 22 sub 3, little a, and the definition of structure. That's a fixed structure of any kind other than a building. its brackets as defined by section 21 sub 3, but you'll have seen that the definition in section 21 sub 3, it is only that partial inclusive definition. And that's where the point that all buildings are structures, but not all structures are buildings, which impressed the upper tribunal, comes from. I'll develop my submissions on that under ground 1 when I get there. 22 sub 4, like section 21, section 22 is also subject to section 23. So if we turn now to section 23 on bundled page 26, that's the exception, or the various exceptions to the exclusions that are set out in 21 and 22. And just in terms of the structure of the provision, what we're interested in, and this is mainly relevant to the cross appeal, but I'll just deal with this now because the way this all fits together, it matters for the purposes of my appeal too, is section 23 sub 3. And that tells you that sections 21 and 22 also don't affect the question whether expenditure on any item described in list C is, for the purposes of this Act, expenditure on the provision of plant or machinery. And then there's a limitation on that in subsection 4. And then you've got these various specific items. So in terms of the drafting technique, what Parliament has done is identified particular items of expenditure that are unaffected by sections 21 and 22, just using the language immediately under list C. And when we come to Mellor Friends cross appeal, the relevant items upon which reliance is placed, you'll have seen item 1, machinery, including devices for providing motive power, not within any other item in this list. Item 4, manufacturing or processing equipment, is the bit of it that's relied on. And then item 22, the alteration of land for the purpose only of installing plant or machinery. They're the 3 matters raised on cross appeal. I would simply note, in addition to those at this stage, items 20 and 21, specific provision in relation to buildings. So there are certain types of building accepted from the exclusion in section 21. So item 20, within list C, buildings provided for testing aircraft engines run within the buildings, and item 21, movable buildings intended to be moved in the course of the qualifying activity. So those are the provisions themselves. I said earlier that the scope of the notion of plant in that general rule in section 11 sub 4 sub A, that's been built up through the case law. And I've made a number of headline points about those case law principles in paragraphs 14 and 15 of my skeleton. And it's maybe just worth touching on those. I don't understand there to be any controversy about the principles themselves, but where the dispute arises really is in what the FTT did in terms of its application of law to fact. And what the easiest way of doing this is probably just to touch on the principles and then shortly show you Cheshire Cavity before I get into the grounds of appeal, because that's a very recent decision of this court setting out the relevant principles, and that I think will provide a helpful framework for the specific points that I've then got to make. But just to trail where I'm going, paragraph 13, actually, first of all, the case law development, it is very long-standing, goes all the way back to Yarmouth in France in 1887. And it's that definition from Lord Justice Lindley of whatever apparatus is used by a businessman for carrying on his business. And then he excludes stock in trade. But then he says it's all goods and chattels fixed or immovable, live or dead, which he keeps for the permanent employment in his business. And where we've got to, and this is really as a matter of almost common law development. It is statutory interpretation of the term plant, but this is probably the closest thing that one can get to a common law subject in the tax field, I suppose, is that notion of plant in section 11.4a, that excludes the premises or the place in or upon which the business is conducted. And among other cases, that's Wimpey and Warland, which is cited in paragraph 14, and that's applied by this court in Cheshire.
When I had to deal with these matters regularly as a revenue junior, I remember finding Hoffman J's judgment in Wimpey a wonderfully illuminating starting point. Would you dissuade me from still taking that?
No, I wouldn't seek to dissuade you because those principles they are applied by Lord Justice Lewis in Cheshire Cavity, and that distinction and particularly the greater recognition of the role of is something premises and the importance of the question of asking not just does this thing that I'm looking at have a function in the trade, but going on to say, what is it functioning as? Is it functioning as apparatus? Or is it functioning as premises? That, I think it's fair to say, that was the real insight that Mr. Justice Hoffman's judgment upheld by the Court of Appeal in Wimpey provided great assistance in pointing the way to asking that question. So just sticking with the background principles for a moment, and I'll make this good showing you Cheshire Cavity. I think that's probably the easiest and quickest thing to do. I could show you lots and lots of cases, but I suspect I would try your patience and run out of time. There was a time when it was up for argument, and this was the point Malone and Friends sought to persuade this court of in Cheshire Cavity, that any plant-like function would mean that the item in question had to be regarded as plant. And that really built on observations in the case law that premises were, in inverted commas, mere setting. So it was said, mere setting, that means that as soon as you have a plant-like function, so a trade function of some kind, that stops the thing in question from being premises, it must be plant. Cheshire Cavity confirms essentially applying reasoning that you can now trace back to Wimpey and Warland that that's wrong. It may instead be appropriate to ask whether it's more appropriate to describe the item as apparatus on the one hand or as premises on the other, and it is not sufficient for a taxpayer simply to say there is a plant-like function, therefore it is plant. And the reason for that really lies in the point we make at paragraph 15 sub 1 in the skeleton. And this goes back to Wimpey and the Court of Appeal and also a case called Scottish and Newcastle. Functions can be performed in different ways. So you may have two things performing the same function, but it doesn't follow that both of those things are plant, because one of them may function as part of the premises. The other may function as part of the plant. In Scottish and Newcastle, the particular example was the provision of atmosphere in the hotel. And the insight was, well, you can provide atmosphere by having nice china, plates, table linen and the like, that would be plant. You can equally have atmosphere by having beautiful gardens and a beautiful building. Both are providing atmosphere, but one is premises and one is plant. We also see when we look at the cases that at least normally one would not regard buildings as plant. That's Carr and Sayer. And buildings don't cease to be buildings and become plant just because they're purpose-built for a particular trading activity. And again, that was also Carr and Sayer. And I suspect it's a case that Mellor, Launcelot Henderson will recall having been a part of it.
I honestly failed in trying to persuade the then Vice Chancellor. It fell on the arm side of the line.
No, you succeeded in persuading him it was on the building side
yes.
of the line. And equally, and again, I'll look at this case in more detail later, this is Bradley and London Electricity. If you have a structure or a building, it's not enough to make it plant. that it's been carefully designed to accommodate the equipment within it. That was a case. We had an electricity substation under Leicester Square, and it had, among other things, explosion-proof, blast-proof walls, held that it was not performing a plant-like function. It was just housing the equipment within it. And then you get a particular application of that in a case called Gray and Seymour Garden Centre. That was essentially a very large greenhouse. It was called a plantarium. I think it was a new term for me when I first read that case. So you had a structure, ornamental plants inside, and the structure gave the plants an environment in which they could best grow. Held, that was premises and not plant. And the fact that you could identify a function of nurturing and preserving plants, as Lord Justice Norris said, that didn't mean that it was transformed into something other than part of the premises. It was still just a purpose-built structure, so it was on the premises side of the line. I also note, and again, I'll show you this case later on, all of this depends on the facts, but housing, machinery and containment, they are normal functions of premises, and you can see that by way of example in a case called Atwood and Anduff Car Wash. That this was about a car wash building, and the argument essentially was, well, is it one very large piece of machinery? And this court said, no, it's not. It's premises. It functions as premises. It houses the machinery that's being used. It's the place where the operations are carrying out. And as to the things that it does, it retains noise. In the winter, it retains heat. It provides protection from the elements. So those are some of the principles from the case law on the plant premises distinction. I just want to make a couple of further observations, and I think the easiest way of doing this is just to show you Cheshire cavity, because that picks up a lot of the authorities. That's probably the most efficient way of sketching this out before I jump into the middle of the grounds of appeal without having properly laid the groundwork. Before I go to Cheshire cavity, I should also say this, that the court will of course know that there have been cases, and the two most famous ones are probably Berkeley Curl and Schofield and Hall, and my own friend understandably tries to make something of both of them, where large structural items have been held to be plant rather than premises. In Berkeley Curl, it was the dry dock, which was viewed by the House of Lords as essentially simply a very large machine. The fact you could also describe it as a structure didn't stop it from being plant on the facts in that case. And in Schofield, it was a grain silo, and the particular role of the grain silo, in particular in enabling gravity to be used as part of the grain storage and processing operation, that had entitled the special commissioners to find that the grain silo was functioning as plant rather than as premises. So there were those quite celebrated cases. This is before the enactment of what's now Section 21 and 23, where taxpayers had succeeded in persuading courts that large structural items were nonetheless plant. There were also, of course, numerous cases where taxpayers argued unsuccessfully that large structural items were plant. And in particular, Gray and Seymour Garden Centres and Atwood and Anduff, they're both examples of cases that were actually going through the courts at the time that the Finance Act 1994 changes were made. We've got in the bundle the Hansard extracts. I'm not going to take you to it just now, but you can see some discussion in the debates of specific pieces of litigation that were ongoing. They don't name the cases, but they talk about greenhouses, they talk about the car wash. You can see that what they have in mind is actually the progress of respectively Gray and Seymour Garden Centres and Atwood and Anduff. And it's against that background that Parliament enacted the legislation that is now in sections 21 to 23. And I'll develop my submissions on this, but it's clear in context against that background that what Parliament was doing was looking to place a limit on the concept of expenditure on the provision of plant and machinery. You can see that in terms in section 21 sub 1 itself. It's telling you that that concept of expenditure on the provision of plant and machinery, it doesn't include expenditure on the provision of a building. And that new rule that's enacted with Parliament having well in mind the developments that the courts had undertaken in the common law test, and particularly their emphasis on function. And we do have some guidance from this court as to purpose of those provisions, which is in the SSE generation case. And that's in Authorities, Volume 3. It's tab 42. And it's particularly paragraph 19. But you'll see here Lady Justice Rose, as she was, starting by setting out the legislation. Noting paragraph 17, section 22 sub 2, reflecting Berkeley-Curl, because you'll recall, I suspect, in Berkeley-Curl it wasn't just the expenditure on the dry dock, it was also expenditure on the excavation to put the dry dock in place. And then 18, the point about 23, limiting the application of 21 and 22. And then could I just ask you, please, to read paragraph 19. And that's on the purpose of, well, sections 21 and 23, but particularly list C. And the reference within paragraph 19 to paragraph 66 in the upper tribunal's decision, you can see that a couple of tabs further back. It's tab 40, and it's bundled page 774. And this was the upper tribunal referring to some Hansard material, really by way, I think, of contextual scene rather than pursuant to any application of pepper and heart or anything like that. In this case, both the FTT and the UT looked, I think I'm right in saying, at the background parliamentary material, but some of it is quoted in paragraph 66 by the upper tribunal, and you see that language of draw a line in the sand in terms of the one-way development of the case law. So there was clearly a concern that courts might be taking the functional test further than Parliament wished them to, and trying to ensure the law doesn't develop further, attempting to take the existing law and case law and entrench the understanding of the different classifications. And I'll come on to this in more detail, but an important part of my case and a point that I say was overlooked by the upper tribunal is the importance of being clear about the manner in which that entrenching happened. Because you need to look both at section 21 and this introduction of a new rule about buildings, and also take into account the technique of having this list of items in list C, which are going to be preserved. And you can see when you look at the parliamentary material at least, but I'd say it's fairly obvious from the context anyway, that what Parliament had in mind was either the outcome of particular cases or the way in which particular things were treated in practice at that time. And so what's happening in 1994 is Parliament saying we're not going to remove that treatment. We'll make provision for that to continue. But what we don't want is the ability for there to be further development of this case law and for yet further things to be recognised as constituting plant rather than premises. We've got at the very back of the authorities bundle, I probably should just show you this briefly. As I say, there's no suggestion this is pepper and heartable. This is contextual C in the two tribunals below looked at it, so I should probably show it to this court as well. But this was what Mr. Dorrell, the minister, had to say. Authorities for tab 53, and this is the original of that passage that the upper tribunal in SSE set out at 66, and which is being referred to by Lady Justice Rose. And there's quite a long extract from Hansard that's been included in tab 53, but I think all I need are the bottom right-hand column at 1140, which is sidelined, so starting Mr. Dorrell, clause 110 introduces, and then the first and second paragraphs on page 1141 over the page also sidelined. I don't think I need any more than that at this stage, so perhaps I could simply ask the court to read those three paragraphs. And you can see at the end of that third paragraph the reference to revenue practice. I'm not going to take up time doing it, but as putting one's tax anorak on one for some of the provisions in list C, one can go through them and say, ah yes, that's whichever case, that's Berkeley Curl, the one that talks about dry docks, or that one talks about silos, ah yes, that must have been looking to preserve the outcome in Schofield. One can't find a case for every item. But this was the point that Mr. Dorrell was making at the end of paragraph 3, that actually for some items there was a practice to accept that certain things were planned.
Can you help me with one small point on the second paragraph? Where Mr. Dorrell refers to allowances becoming available at a higher rate than would otherwise be the case.
So,
puzzled by the otherwise.
I think at that time, I'd need to double check this to make absolutely sure this is right, but I think at that time, if you had something that was premises, it would likely have attracted industrial building allowances.
Oh, I see.
but of course they were later removed. And this was a point that did away with the upper tribunal. I say wrongly because they said, oh, well, these facilities wouldn't get any allowances at all. But that's just a result of a change in the legislative scheme. Parliament has since enacted a new chapter in the Capital Allowances Act. So you do have structures and buildings allowances, which on the face of it would apply to facilities like this, but that's later legislation and doesn't help learner friends clients. But at the time that Mr. Dorrell was speaking, he had in mind a situation where you had a particular rate of write-off if you had plant and machinery allowances. If, however, it were premises, it either would or at least was likely that it would be covered by some other type of allowance under the Act. And the most likely one is IBAs, which applied at that time, but that was a less beneficial rate.
In the absence of any specific statutory provision, it wouldn't be deductible in computing your trading profits,
Correct.
because it would be capital expenditure.
Correct. But I think that's the answer to you.
Yes, and even though if you're producing your accounts showing a true and fair view of the business, you might well write down your capital assets, but that would then have to be taken out.
Correct.
In computing the taxable.
Correct, under the exclusion for capital expenditure.
Thank you. That's the point that was I had the back of my mind.
In sub F, yeah.
Whether that might be what Mr. Dorrell had in mind. But anyway, thank you.
So we've got that Hansard material by way of contextual scene. It does give a little bit of insight into what Parliament was trying to do. It doesn't, of course, govern the interpretation of the legislation. But one can see, simply by putting oneself in the shoes of the draftsman, as at the time that those changes came in, the draftsman would have been well aware of the developments if I can call it loosely, I don't think it is right to talk about the common law of plant, but the judicial approaches to the interpretation of that plant. And one can see at least illustrations in the case law of a more expansive approach to circumstances in which plant and machinery allowances are available, including in relation to large structures. One can also see the attempts by taxpayers, albeit unsuccessful, to test the boundaries of the distinction between plant and premises. Even in cases where ultimately that's unsuccessful. There were some instances where taxpayers succeeded at first instance. Atwood and Andalf is an example of that, where the taxpayer wins in the commissioners, and then that's overturned on appeal. So you can see what Parliament is trying to do. It's very much saying, thus far and no further. There's a further inquiry that needs to be done. Is this a building within Section 21? Is it a structure within Section 22? Does one of the exceptions to these exclusions in Section 23 apply?
Also, one aspect of the background, perhaps I may be misremembering, but I seem to remember anyway that there were some notorious cases really dragged on interminably before the social commissioners, dealing with disputes about capital allowances, practically until the crack of doom.
I believe that it is also right that there were some very lengthy fact-intensive hearings in the special commissioners about, and possibly the general commissioners, about issues like this. Sorry. Mr. Peacock reminds me, car parks were a particular offender in that context. It's before my time. But,
I think perhaps there was a general feeling that this area of the law had got a bit out of control.
Yeah. So we've got that effort to reassert control, if I can put it that way, in what's now 21 to 23. We've also, and this is subsequent to the enactment of sections 21 to 23, which is why I'm doing this last, had the further clarification from this court about the premises test in Cheshire Cavity. And so I was just going to do that last by way of my overview and background points. I mean, strictly, I suppose this belongs under my ground 2, but it does frame some of what I'll say in relation to ground 1, and it is a very helpful summary of principles. You get Cheshire cavity in Authorities Volume 3, tab 44. And if I can pick it up at paragraphs 1 and 3, first of all, in Lord Justice Lewison's judgment, Lord Justice Baker and Lord Justice Whipple agreed. What we were dealing with was expenditure that was incurred on introducing water into rock, and this was an engineering activity. So it dissolved the rock and it created a cavity, and then the idea was that you'd be able to store gas in the cavity. And so the argument for the taxpayer, presented by learned friend as it happens, was that this was expenditure on the provision of plant and machinery, and the cavity wasn't simply premises. There were also issues which the court ultimately didn't have to consider about the exclusions, particularly in section 22. But first of all, paragraph 3, guidance from this court as to how an appeal is properly to be approached. And in particular, the observation that a decision whether something is or isn't plant is a question of fact or a question of fact and degree. And sometimes it's possible to take either view. That's an observation that's got a very long history. In the authorities, you can trace that back at least as far as Scottish and Newcastle at the start of the 1980s and maybe sooner. And of course, the observation that sometimes an appellate court will say, well, the fact-finding tribunal was entitled to find as it did. It doesn't, of course, follow that the tribunal would have erred if it had come to the other conclusion, or at least it doesn't necessarily follow that the tribunal would have erred if it had come to the other conclusion, precisely because some cases are capable of decision either way without any error being made.
Yes. At first blush, it does perhaps strike one, or sometimes strikes me as a little odd that this should be a question of fact or fact and degree rather than a question of law. I mean, in other areas, for example, whether a receipt is capital or income, it's a pure question of law, and the authorities are very clear about it. One might, I mean, in a fiscal context, one perhaps expects a rule which will produce a hard-edged conclusion rather than the possibility of differing results and identical facts, just depending on the tribunal that hears the case.
Well, I do see your lordship's point, but I think what is very clear is that we are not dealing with such a rule.
No, I agree with you. It seems to be entirely clear on the authorities. Where we've reached is precisely as Lord Justice Lewison says.
Yes, it may have been, I suppose, capable. It's a concept that might have been developed in another way, as your lordship says, rather like income or capital, to permit a more hard-edged analysis. But that's not what we're dealing with.
Yes, thank you.
I wasn't going to take that time with the detail of the underlying facts. It very much was as simple as hole in ground being created by insertion of water and storage of gas. What is quite useful is the treatment of the authorities. I don't particularly want to go paragraph by paragraph, but you can see Lord Justice Lewison dealing with a large number of the cases going all the way back to Yarmouth and France, paragraph 19. What he's doing that for is to deal with the submission put on behalf of the taxpayers that's recorded at paragraph 24. And this is the point that was being made on the appeal to this court, is that where an asset's got both a plant and premises or settings functions, the asset should be classified as plant unless it's merely premises or setting. It wasn't whether the asset predominantly performed a premises function rather than a plant-like function, nor was it whether it was more appropriate to describe the asset as premises or setting on the one hand or plant on the other. And this was the point that was being put to this court, was a very stark one. and actually perhaps taking matters closer to at least a harder-edged question of law. It's the point in the final sentence of paragraph 4. As soon as it's found that an asset has any plant-like function, it qualifies as plant without more unless specifically excluded by legislation. And what Lord Justice Lewison does is go through the authorities in order to assess that submission. And if I just give a couple of examples, which should, I think, save time, because it should, I think, save me actually going to these cases later.
Well, I think you can take it. We will all have read, if we haven't already, I mean, the whole of Lord Justice Lewison's stuff.
Well, in that case, I'll take it very short, just to illustrate. For example, Gerald and John Good, the point in relation to the movable petitioning that either view could have been taken. Paragraph 29, he says that rather shows that any plant-like function, that can't be determinative. And then similarly, dealing with Berkeley Curl, there are the recitations of the very well-known passages from Lord Reed's judgment in that case, and looking at the dry dock, you see at 32, the decision really turned on the characterisation of the business, because Lord Reed observed if you looked only at the second stage, so that was the inspection and necessary repairs, then it was not difficult to say the dry dock was just setting, but actually the real point for Lord Reed was that every part of the dry dock, it played an essential part in getting large vessels into position. So really it was, put short, it was in the nature of a big machine. You could also describe it as a structure, but if you were looking just at, if I can call it the common law test, the majority in Berkeley Curl put it on the plant side of the line rather than the premises side of the line. The minority took a different view. And then at 34, emphasis laid on the use in Berkeley Curl of those words merely and mere in relation to setting. But Lord Justice Lewison says, no, that didn't mean that the any function approach was right. And then I'll skip over Cook and Beach Station Caravan at 46, Skerfield and Hall at 47. Although just to note on Schofield and Hall, paragraph 51, Lord Justice Lewison does pick up the use of the language in the Northern Ireland Court of Appeal of less appropriate, it being less appropriate to describe the walls of the silos as mere setting, and that's suggesting an evaluative assessment. 55 is the reference to the well-known passage in Scottish and Newcastle. We've got the original in the bundle. I wasn't going to take you to it, but these are the points that Launcelot Henderson raised about the development in the authorities, about this being a question of fact and degree. And Lord Justice Lewison makes some observations on that. In paragraph 56, and so he notes, just above letter J, that if you're just looking at whether an asset has a plant-like function, that might well be a question of fact, but then noting that a question of degree involves some form of qualitative assessment, and again he says that's inconsistent with the taxpayer's submission. That, of course, is the submission that we looked at paragraph 24 about any plant-like function. I should just touch on paragraph 57, arising out of one of the questions put to me earlier about Mr. Justice Hoffman, because that's got his explanation of the Yarmouth and France distinctions, which it was that helpful observation in particular by the letter C that the formulation excludes the premises or place in or upon which the business is conducted.
And we also get the reference to the approach to the majority and Berkeley Curl turning on whether it was more appropriate.
Absolutely.
Again, really, it is the point you.
Absolutely.
The whole of this lengthy review is devoted to establishing.
Yes, indeed so. And that, of course, was upheld by the Court of Appeal. There's the observation from Lord Justice Fox, also well known, and this was the point actually I made earlier about Scottish and Newcastle, just by the letter J at the bottom of 635. That's the same function being performed by different things. And so I mentioned the tableware on the one hand and the beautiful buildings on the other. That's where it comes from in Scottish and Newcastle. And then over the page, the fact that different things may perform the same function isn't relevant, and the reason for that is that one thing may function as part of the premises, the other as part of the plant. And then at paragraph 61, that's a reference to Lord Justice Fox in Wimpey, specifically agreeing with Mr. Justice Hoffman on the question of more appropriate. And then there's discussion of Carr and Sayer, which has got the point about under Roman 4, buildings not ceasing to be buildings just because they're purpose-built. And Roman 5 commenting on functions of a building, at least by reference to the particular facts in that case. And then the observation in 66 that in Carr it was the manner of construction that proved decisive. 70 discusses Bradley. And again, it's more appropriate just above letter E. And I will show you when I get to the detail of ground 2 a little bit more about the actual functions that were at play in Bradley. But the key point was that in that case, the particular features that had been identified, which the commissioners had thought were plant-like functions, they just meant that the substation had been purpose-built to enable the plant within to function. So that was held to be on the premises side of the line. That, of course, is before there's any need so before there's any enactment of what's now sections 21 to 23. Then you get the summary in 71, that the premises test is an accurate summary of the law, and that it's not enough to point to some plant-like function in order to conclude the whole of the asset is plant. I can skip over Atwood. And that's another use of the more appropriate language. You can see that in 73. I don't need any of the detail of Shove and Lingfield Park. That was the artificial racetrack. And then on the decision in the case itself, the real problem was identified in paragraph 77, just above the letter B, that no man-made structure or equipment was introduced, planted into the cavities. And 79 noted that just as buildings don't cease to be buildings and become plant just because they're specially designed for a particular trade, so also these cavities don't lose their character simply because they've been formed in order to receive gas consisting of the taxpayer's stock in trade. And that I think on a fair reading of this, that's enough to deal with the appeal. But at paragraph 80, Lord Justice Lewison goes on to say, well, let's suppose you can get over that hurdle. Plant-like function, not only incidental, but actually outside control, only just scrapes over the bar for a plant-like function. There are receptacles in which gas can be stored at high pressure. And so he's clearly sceptical about whether that is a plant-like function. But he then says, well, even if it is, it's not the case that if something performs any plant-like function, it's necessarily plant. Rather, it's a question of fact and degree. That is to say, an evaluative exercise. And one of the relevant tests is the premises test. He says, as formulated by Mr. Justice Hoffman. So that completes the circuit of the importance of those observations from Mr. Justice Hoffman in Wimpey. And so there was no error, this is 82, in the upper tribunal directing themselves to ask whether it was more appropriate, or that it answering the question may involve deciding whether it's more appropriate to describe the item as apparatus for carrying on the business or as the premises in or upon which the business is conducted. And he says at 83, that is the premises test, and it's amply supported by authority. And then in terms of how he deals with the appeal, and I'll come back to this when I look at what the upper tribunal did, he observes that that is a value judgment. That brings in the very well-known principles in Procter and Gamble that were set out by Lord Justice Jacob, and also those in the Sprint Room case. So this is not carrying out the balancing task afresh. It's asking whether the decision was wrong by reason of an identifiable flaw in the judge's treatment of the question, such as a gap in logic, a lack of consistency, or a failure to take account of some material factor which undermines the cogency of the conclusion. And I'll develop my submissions on the upper tribunal's approach by reference to that test. But in Cheshire Cavity, nothing in the upper tribunal's answer to the question that showed any legal error. So there was no mistake that would ground an error of law in asking whether it was more appropriate to describe the cavities as apparatus or as premises. So that I hope speeds up how I can deal with the authorities when we get to the specific grounds, and also I hope gives a bit more context to sections 21 and 23. We're dealing with an interrelated code. We've seen both section 11 and sections 21 to 23 are ultimately addressing the question, what counts as expenditure on the provision of plant or machinery? So there's no logical priority as between section 11 on the one hand and 21 to 23 on the other. And this was a point that we got into a little bit before the first tier, essentially the first tier said, well, it's a matter of convenience. This was the first tier's paragraph 23. It's the balance of convenience in any particular case, which issue one looks at first. My approach is that it's most convenient to start with section 21 and the question of building on this appeal. That's different to how things were done below. It's partly because Ms. Mellor and a friend going first at both of those stages. The reason why it's more convenient is that the first tier has decided that at least some of the items did function as planned, and so on any view it's going to be necessary to look at the building exclusion. And also pragmatic, because before the upper tribunal, less time was spent on the building question. I certainly want to make sure that that gets properly ventilated. So that's essentially why I'm starting on ground one with building. One does have to bear in mind, and that's why I spent a bit of time on the wider context, that when sections 21 to 23 are enacted, Parliament is aware of the judicial developments in relation to the general test for plant. But on ground one, my submission is that the upper tribunal itself erred in law in setting aside the first tier's decision that all the expenditure on the disputed assets was expenditure on the provision of a building. I say that the upper tribunal itself misconstrued the statutory concept of building, and that on any view it should not have interfered with the first tier's conclusion that each of the 5 facilities was a building for the purposes of section 21. In the skeleton, I summarised the basis of the first tier's decision in relation to the building issue in paragraphs 33 to 34. And you'll have seen that it proceeded essentially in two stages. There were certain general points that it recognised, and that was essentially paragraphs 103 to 110, and then it went on to look facility by facility at that question, whether what it was dealing with was a building or not. And what you can see when you look particularly at the detailed treatment is that the first year took into account both the characteristics of the facilities and also their functions. It weighed both up, and having done that, it held that overall each of the facilities was properly to be characterised as a building for the purposes of Section 21. And I say that that approach was perfectly conventional. It didn't involve any error of law, and the upper tribunal was wrong to diagnose an error of law in that reasoning. Now, it's of course common ground that concept of a building needs to be interpreted by considering the context and the purpose of the enactment. No one is saying that one doesn't take a purpose of interpretation here, and equally no one, least of all me, is saying that one should ignore the scheme and context of the legislation. What I am saying is that the approach that the first tier took of analysing both characteristics and functions, that was a perfectly permissible approach. I say that the upper tribunal was wrong to seek to elevate to a principle a proposition that function must be particularly important, if that's really what they meant in paragraph 130. Because you'll have seen, and we may well end up discussing this a little bit more, there is a little bit of an oddity in the upper tribunal's reasoning, because it labels what it's doing as identifying various different ordinary meanings of the term building. You see that in 129 of the decision. And that's slightly odd, because of course what the ordinary meaning is a question of fact. You wouldn't expect to be getting into that in an appeal on the law. Probably what they're actually doing is identifying different contextual meanings. I'm probably not helping anybody if I try and get bogged down in the label of ordinary meaning. I could say, oh look, the upper tribunal went wrong because what the ordinary meaning is a question of fact. It shouldn't have been doing this. What on a fair reading it's probably doing is looking at different contextual meanings. But what they say at 130 is that there's an error of law because the wrong approach was taken, because essentially more weight needed to be given to function. Now, 2 points on that. First of all, that doesn't work because it would not be right to say, as a matter of interpretation, that necessarily greater weight needs to be given to function. It must all just depend, ultimately, on what it is that has been built and what it does. So both nature, characteristics, and function. They're all matters that the first tier can look at, and how much weight to give to those items in any particular case is going to depend on the context. There isn't any point of law that arises here. But I also say that actually when you look at what the first tier did, and you look at the reasoning more closely than the upper tribunal did, and I'll show you this, it's particularly stark in relation to the uranium oxides tour. Even if this court were attracted to the upper tribunal's approach, actually what the FTT has done caters for it, because it is weighing up appropriately both characteristics and function. So that's the sort of headline for the complaint under ground one. My starting point is that when we're looking at section 21 and that notion of building, one should be bearing in mind that the term is one, first of all, that's used in ordinary language. Secondly, it doesn't have any established legal meaning or any special technical meaning. And indeed, and this is a point I make in the skeleton, if you look at the submissions that were made below, this is my paragraph 38, even Mellor Friend was saying it's not a specialist term, so you weren't going to go and ask a civil engineer what he understood or what such a person understood by the concept of a building. Rather, and these were Mellor Friend's words, they are ordinary English words. And thirdly, that term building, it's not defined in the statute. I mean, there is that partial definition in 21 sub 3, but it is only partial and only inclusive. Now, in those circumstances, my submission is it was perfectly legitimate for the first tier to take as its starting point the ordinary meaning of the term building. We see that very point in the Guy case in this court. It's paragraph 22, and I'll show you that shortly. Just sticking with the help that we get from the legislative context, and I've touched on these points already, but just to wear them under ground one. I said we've got the inclusive definition in section 21 sub 3. If one looks at the inclusive definitions, this is Authorities 1 and page 23, or if it's easier, the first tier has this set out at paragraph 15 of the decision. I don't mind where we look at it. But that reference in section 21 sub 3 little b, this is just sticking with scheme and context for the moment, to an asset of a kind normally incorporated in a building. If anything, that suggests it's the ordinary meaning of the term that Parliament has in mind. It's that reference to normally. That does, if anything, rather point one in the direction of what the usual understanding of what a building is as a matter of ordinary language. It's also relevant, again, if we're sticking with scheme and context of the legislation, that the legislative technique here has been to make specific provision for certain types of building in List C, among other items, of course, as well. And those certain types of building, they're removed from the scope of the exclusion. And that was why, in opening on the legislation, I emphasised in particular items 20 and 21 at bundle page 27. So those two particular types of building are specifically identified. And again, in terms of purpose and context, the relationship between section 21 and the common law test for plant, that is also important because, as I've said already, when Parliament enacted what's now sections 21 to 23, it was well aware of the common law approach to the interpretation of the concept of plant. It would also have been well aware of the premises test that had been identified by 1994 in Wimpy, among other cases. And as this court noted in the passage I showed you in SSE, para 19, the intention of these provisions is to draw a line in the sand and to entrench the understanding of the different classifications. So if one stands back and looks at section 11 and 21 to 23, what Parliament is doing, and I'll focus on 21 for the moment, is adding a further inquiry over and above the common law test into whether a given asset is to be characterised as plant. So you don't just stop with the common law test of whether the item can more appropriately be characterised as functioning as equipment or apparatus. And you don't do that because that gets you straight into the sorts of problems that arose in cases like Berkeley Curl or Schofield, where although you have an asset that is a substantial structure, nonetheless, the taxpayer succeeds in saying it passes the functional test, therefore it's plant. And you also avoid even having to get into the sort of debate that's had in Carr and Sayre, where it's, well, it's a building, but nonetheless, this is a very functional building, therefore it gets over the common law test. What Parliament is doing is saying, no, you can just ask, is this thing a building? If it's a building, then it's excluded unless one of the exceptions in list C applies. And so, for the purposes of ground one, I suppose I am assuming against myself, because in order for this to be relevant, Learner Friend's got to get home on the common law plant premises test. Or I'm saying, well, I can just short circuit this by saying what we've got answers to the description of a building. And then it's subject to the cross appeals, whether for some of the items, one can say that either item 1 or item 4 or item 22 nonetheless overrides. So what about the general approach? I'd like to show the court, if I may, two cases fairly swiftly, because the correct approach is always going to turn on the particular statutory context, and there's really no authority other than this case that's looking in any detail at the exercise that we have to look at here. But there is guidance on the approach as a matter of generality from this court relatively recently in Guy, and then some helpful observations in a much older case in the High Court called Morrison. If I can just briefly show you those two cases. Guy is in Authorities, Volume 2, and it's tab 31. Do with statutory provisions relating to crematoria, and obviously ultimately it turns on the particular statutory and factual context, but there is guidance of a general nature that does, in my submission, assist the task here. If I can pick it up, it's Lord Neuberger, with whom Lord Justice Moorbeck and Lord Justice Etherton agreed. And you can get enough about the facts. If I just summarise paragraphs 1 to 3, the claimant was an Orthodox Hindu, and what had happened was he'd asked the local authority to set aside land to be dedicated for a funeral pyre, and the authority refused that request, and he sought judicial review of the refusal. The case was argued at first instance on a particular factual basis about the sort of structure that would satisfy the claimant's religious belief. And if you look at paragraph 3, you'll see that that factual basis had shifted by the time the case came on in the Court of Appeal. Because the point was that his religious belief would be satisfied if the cremation process took place within a structure. That was provided the cremation was by fire and that sunlight could shine on the body while it was being cremated. And so the question the Court of Appeal was asking was whether the structure of that nature would infringe the relevant legislative requirements relating to cremation, and which it then sets out on the next page. It's report page 661, bundle page 541. And because the reason in all of this matters is if you look by the letter B, in paragraph 7, the expression crematorium, that was defined as any building fitted with appliances for the purpose of burning human remains. And then just a couple of points on the legislation under consideration. Para 8, Secretary of State required to make regulations for the maintenance and inspection of crematoria. That was a later provision in the Act. And then if one goes down to paragraph 9, just above the letter H, the reason this was important, or the distinction between structure and building was important, was Regulation 13, because that dealt with a place where cremation may take place. No cremation may take place except in a crematorium, the opening of which has been notified to the Secretary of State. And so paragraphs 10 through 12, that's the court putting the legislative material into context. And in particular, it's Roman 1, and the cremation could only lawfully take place in a structure which is a building. That was the combined effect of Regulation 13 and Section 2. I don't need to take up time with the various other requirements. And you see that at the end of paragraph 12. That's the only outstanding question. Could you have a cremation according with Mr. Guy's belief in a structure which is a building, read short, within the meaning of the Act? And then there's some discussion in paragraphs 13 and 14 about the sort of structure that would be required. And so in this case, they're saying, well, that there can be a structure, but there needs to be a substantial aperture to let sunlight fall directly on the body. And then that's set out in more detail that I don't need in paragraphs 14 to 18. What the Secretary of State said, and you see this at paragraph 21, is that there would be an infringement of the legislation, and if this were right, that would then raise issues about Human Rights Act compliance, conforming interpretation, and the like. But this court was dealing with the prior question, was there an infringement? Paragraph 21, the submission was that a structure could only be a building within the Act if it was an enclosure of brick or stonework covered in by a roof, and that relied on some observations of Lord Esher in Moore and Williams, because that was essentially what he'd said in that particular case. And so the Secretary of State is saying, well, applying the normal meaning of the word building, what Mr. Guy wants isn't one of those, so you can't use it for a cremation. Para 22, 2 points arising out of this. First, the one I've made already, that the meaning of the word, or putting the point another way, determining whether a particular structure is a building, that must depend on the context in which the word is used. That's obviously right. But then the second point is of some significance when one looks at the first tier's approach in this case, where, as was the case in Guy, and actually as is also the case in relation to this legislation, where the word's one used in ordinary language and doesn't have an established special legal or technical meaning, and is not defined in the document in question, of course that's the Act, one can usefully take as a starting point the word's ordinary meaning. So the objection that the first tier went wrong in saying it thought that you should look at this word in a way that's consistent with ordinary usage, I say that fails because of what's said by this court in paragraph 22 in Guy. It is a matter of context, but there's no problem in a case like this with taking as a starting point the ordinary meaning. Paragraphs 23 and 24, Lord Neuberger goes on to observe that the definition that had been set out in Moore, so that was an enclosure of brick or stonework covered in by a roof, actually was too narrow to provide the ordinary meaning of a building, because he says at the bottom of paragraph 24 that actually in normal parlance the word building is naturally used to describe a significantly wider range of structures than would be included in that formulation. And then 25, he goes on to give some examples. So structures not made of brick or stonework, and he says chalets, stables, industrial sheds, and he goes on wood drying stores, bandstands, etc. He says on the basis of a normal meaning that they're all buildings. And he also mentions the pyramids and the Colosseum. I don't want to dive down the rabbit hole of looking at other things that one could build. We're interested in the facilities in this case, but that does give a sense of the breadth of the concept as a matter of ordinary linguistic usage. Paragraph 26, he notes it could be an iterative process, and it shouldn't matter whether you start by making a prima facie assumption about meaning and then look at context, or whether you look at the context and then look at the word. But he does say this, that if you are going to start with a preliminary assumption, I don't think it would be right to take a somewhat artificially narrow meaning of the word and then see whether the context justifies a more expansive meaning. He goes on, it's more appropriate to take its more natural, wider meaning and then consider whether, and if so, to what extent the meaning is cut down by the context in which the word is used.
And you will urge upon us that approach in the present case?
Yes, I
I
would.
understand.
Yes, indeed. 27 to 31 I can skip over because they're addressing a number of matters specific to the particular statutory context in that case. And I can pick it up at 32 and following, where he goes back to the proper approach. And he reminds us that the issue is whether the sort of structure in which Mr. Guy wants his remains to be cremated in due course, would that be a building? And 33 notes that the question, it's not so much what is meant by building in the section. He says that's somewhat abstract. Rather, it's the more specific question whether a structure acceptable to Mr. Guy would be a building within the section. And he goes on to say, and this is a cautionary note, that at least in general, it's inappropriate for the court to seek to define a wider expression used in the statute where the legislature has not done so, because it would virtually be a judicial encroachment onto the legislative function. And he says, of course, judicial guidance is inevitable and helpful, but he says a conscious and unnecessary definition of the word by the court is another matter, and indeed they'll often lead to problems. So he's deprecating an approach based on definition. Rather, we're looking really at whether the particular thing that we're looking at, does it answer to the description or not. And what he does, in particular, is look at the Act and its aims. And I don't want to dwell on this too much, because obviously the aims of the Cremation Act are not necessarily the same as the Capital Allowances Act, but you can see the sort of reasoning. Uniform rules enabling the Secretary of State to regulate, and he placed some weight on the fact that crematoria would be constructed, and so he puts those factors together, and he says, well, look, provided it's relatively permanent and substantial so that it can be said to have been constructed, and provided it could normally be so described, a structure will be a building within the Act. I think provided it could normally be so described, that means provided it could normally be described as a building. And so he says, in the light of those factors, there's no reason not to give the word building its natural and relatively wide meaning when it comes to Section 2. And of course, that's the meaning that he set out in paragraphs 21 to 26. And that's essentially repeated in paragraph 37. So the wording of the Act doesn't detract from adopting the natural and relatively broad meaning of building in Section 2. He says that a structure, to be a building, it's got to be relatively permanent and substantial, and that may remove some structures from the ambit of the Act. But if a structure is not relatively permanent, can't be described as constructed, it would not ordinarily be described as a building. And then there are various other factors in 38 specific to that statutory context. And that's what finds the conclusion that there wouldn't have been any breach of the provisions of the Act or the regulations if a structure of that kind had been used. And that was because such a structure would be a building for the purposes of the Act. And that sort of approach can perfectly sensibly be applied in a case like this. Not to rely on definition, but actually to look at scheme and context, take what lessons one can from the Act itself, and then to stand back and ask, is the thing that I'm looking at, does that fairly answer to the description of building? And one can see, and this is a much older case, certainly High Court, not this court, but in 1915, a case called Morrison and Commissioners of Inland Revenue, which is in Authorities Tab 1 at Divider 8, one can actually see, not in as much detail as the approach set out by Lord Newburgh, but actually ultimately a similar approach. This is Mr. Justice Rowlatt dealing with yet another tax case. This one concerning walls in a field. We're looking at a farm, and fields that made up the farm, they were divided from one another by substantial stone walls. They were 5 to 6 feet high, and the walls, they divided up the land, and livestock could shelter. And it mattered for the purposes of a 1910 Finance Act, when it came to valuing the land, whether the walls either were buildings, and there was also an issue whether they were structures appurtenant to or used in connection with any such buildings. You can see that from headnote, report page 716, bundle page 47. And you can also see it from report page 721, where the judgment of Mr. Justice Rowlett begins. And you can see he poses the question in the first sentence of his judgment, and then he gives the factual background in the rest of that first paragraph. And he notes that in this particular section he's looking at that word building. It had no limitation, nothing in the section which shows what is meant, other than that it went on to provide that other structures appurtenant to or used in connection with any such building would also be exempt. And so he got a little bit of a clue out of that. You can see going over to the top of page 722. What he goes on to say, just above the first hole punch, is it's quite clear that the expression building doesn't mean everything that can by any means be described as built. It means buildings in a more narrow sense than structures, because there are other structures of a limited class which under the terms of the subsection may also be taken into consideration. And so he goes on to say, well, because I've got to put a more or less limited sense on that word building, he says the only way to construe it is by looking at the nature of the property which is being dealt with. He says it's impossible to hold that it depends solely on the character of the workmanship. And he gives the example of a wooden paling. He says, well, that's not a building. But if you had exactly the same character of work, if you made a corner and put a roof on, you might call that a building, a bit like a shed. So he says, not just about workmanship. He says the character of the erection by the second hole punch and the nature of the property on which it is and its function on that property must all be looked at. And he gives the example of a fives court. And he said, well, in that case, it's an erection that's being used on the land. It's a building upon that land. And then he moves away from the example of the fives court, and he goes rather closer to the case at hand. And at the bottom of page 722 in the report, he says, in the case of a farm, the question which must be considered is, in my opinion, what are farm buildings? That seems a straightforward and sensible way of construing the section. And then over the page, he refers to a case in this court that an earth embankment, that wasn't a building. And he goes on to say by the first hole punch, I think the word buildings in relation to a farm means what one would ordinarily call farm buildings. And then he draws a contrast between that and the stone walls that he's looking at in that case. He says, well, look, no one conversant with farming language would describe the walls in that way. So that's a much older case, but what you have is the court testing the ordinary understanding of the term building in the particular factual and statutory context in which it arose.
And the walls in that case were dry stone walls, I would think. Well, it sounds as though it's a kind of more benign context. I've got it completely wrong.
I think that's probably right.
In which case, well, that may perhaps help reinforce the instinctive view that they're not really buildings.
Yes.
Because they're not even held together by a mortar.
Sure.
They are basic.
Sure. I could certainly see that.
Yes, constructions.
And I don't need to take up time with the other limb. Other structures are pertinent to are used in connection with any such buildings, because the wider point is we didn't have any buildings. And so if you look at what the first tier did in this case, I say that is perfectly in line with the approach in the authorities as to how one should construe a term like building, which is not defined in the statute. you can see that you paid attention to the ordinary everyday usage, paragraph 107. But he also went on to consider function. And below, I suppose, I'd been urging on the first tier an approach of saying, well, you just have to look at this thing. You've been to see it. It's a great big edifice. It's made out of concrete. If one looks at, there's a witness statement in the supplementary bundle, you can actually see how thick each of the walls are. You know, 0.5 metre plus thick concrete walls. It's got a roof. It's got foundations. What more do you want? And Judge Cannon didn't go as far as that. He said, well, no, I want to look at function as well. I don't think function's irrelevant. It is a factor. I don't think it's determinative. I've got to look at all the facts in the round. And I ask rhetorically, what is wrong with that? That's exactly what the trier of fact should be doing. There's nothing, as we'll see in the legislative scheme, that points one towards an approach that says it is only where buildings function in a particular way that they count as buildings for the purposes of this Act, or anything like that. What's involved here is essentially a multifactorial exercise of looking closely at what is the thing that's been constructed, what does it do, and I do say that the particular weight to give to those factors is a matter that belongs to the province of the first tier. It doesn't raise any point of law. And the upper tribunal, while it was correct when it said that it thought, this is UT Para 127, it thought the FTT had been correct to decide that both characteristics and functions are relevant. It went wrong in the subsequent paragraphs of its decision, where it tried to set out particular contextual meanings and to say, well, in this context, the meaning of the term building, it must be one where function is particularly important. I say there's just no warrant in the statutory scheme for that approach. And so it was wrong to purport to diagnose an error of law on the part of the first tier. Ultimately, what we're dealing with is a question of fact and degree. And the FTT, I say, was perfectly entitled to take the approach of looking at both characteristics and function. You can see the weighing up exercise that it did. I'll just touch on this briefly at this stage, because this is a point I do want to come back to in a little bit more detail. But if you look, for example, at the FTT's treatment of the cylinder handling facility, paragraph 115, it looks at what is actually there in front of it. So 4 walls, a roof encloses a substantial volume of space. It looks at what the roof cladding actually does. It accepted the evidence that the roof walls, they weren't intended by URENCO to provide shelter to material equipment, machinery operators inside the CHF. Now, just pausing there, that was right on the evidence in the sense that whoever was designing the cylinder handling facility, they didn't need to provide shelter to the things that would happen to be inside it. But if one just stands back and actually thinks about it, as a matter of fact, what has been built necessarily does keep the rain out, keep whatever heat is in, etc. So there's a slight oddity about subjectively what's going on and objectively what the building actually does. But in any event, the tribunal goes on to say, well, it contains radiation, and that function of containment on any sensible view of the matter, that is something that buildings do. They contain things, both in the sense that machinery and equipment might physically be within them, but they also contain, in the more specialised sense that the FTT was noting in earlier in its decision. You could think of something like a chemical factory or something. It needs to contain hazardous gases, for example. That's something that a building does. There was a lot of emphasis, both before the FTT and before the upper tribunal, quite understandably from a learned friend presenting his case, of saying, well, these things don't provide shelter. And my respectful response to that is that rather misses the context of what it is that's being done. We are dealing with things that perfectly sensibly can be described as industrial buildings. It may be that when they were designed, you didn't need, for example, to shelter cylinders from the rain. So cylinders could sit outside on a raft and be rained upon. But if you put your cylinders inside a large concrete structure with metre-thick concrete walls and a concrete roof, it is a fact that they are being sheltered from the rain. It's a slightly odd point that has developed in this.
Two different uses of the word contain. One, as you say, I guess means comprehending within. In that sense, plainly the cylinders are contained within the CHF. And then we have the containment of radiation, which means really preventing the escape.
Indeed. And
I mean, a prison, for example, contains inmates in both senses.
Well, indeed. And that was, prison is the example that's given in Carr and Sayer. And analogies can always be slightly difficult, but what the upper tribunal seems to have thought, and this is at paragraph 129, when it talks about a central function of a building such as shelter, and it's rather ignoring the obvious point that buildings, just as much as keeping bad things out, if we can put it in that colloquial way, they might just as well keep bad things in. The prison is an example. My example of the chemical factory is another example. There may be different degrees of badness. I mean, if you look at the car wash in Atwood and Andalf, I mean, that contained noise and retained heat. It's not very helpful in my submission to be focusing on shelter. It's also not very helpful in my submission to focus on, as the upper tribunal seems to have done, the purpose for which the structure is designed, because that's going too far into the subjective view of the designer.
So just teasing that out, do I understand your submission there is that if one's looking at the question of shelter, for example, if the structure has a roof, the fact of the matter is it keeps the rain out, even if the rain doesn't need to be kept out.
Yeah, that's right. And that's relevant if you're asking in the particular statutory context, is the thing that's in front of me properly to be characterised as a building or not? Yeah. And I'll come on to the two. There are two specific points that are taken against me, and which founded the upper tribunal's diagnosis of an error of law, and they're maintained by Mellor Frame and his skeleton. The first of those is not all structures are buildings. So you have this nice little refrain that all buildings are structures, but not all structures are buildings, and that somehow tells you that function is very important. And the short answer to that is no, it doesn't tell you anything of the kind. The other is that function generally is very important because an item has to pass a functional test in order to count as plant as a matter of general principle. But again, that doesn't justify any sort of restrictive meaning of the term building, or an approach that says, I must give function predominance when it comes to working out whether what I have is a building or merely a structure. And I'll develop those points in a moment or two. But what I'm saying at the moment in relation to 115 is you can see the FTT looking at the nature of the thing that it's having to analyse. It's looking at what it was intending to do. That was actually arguably a bit generous because it didn't really take in what the thing was actually as much as it might have done, but no matter. I mean, that's a point for me, if anything. It does identify that containment function, and it finds, and there can't sensibly be a point of law here, this is a question of evaluation, it finds that the CHF, it's functioning as a building in containing things. And I'd say that's both the more general meaning of things being inside it and also the containment of radiation. And then it looks at appearance. That's just at the top of big bundle page 246. And then importantly, the conclusion it expresses is an overall conclusion. It says, overall, I consider that in everyday terminology it's naturally described as a building. So this isn't a case where the FTT has somehow leapt for an ordinary meaning. It's a very careful exercise that the first tier's done. Having had its site visit, having had, I think, 3 days of evidence, 2.5, 3 days of evidence, it's looked at what it is that's been constructed. It's looked at what those things are, and it's that overall assessment, looking at all those factors, that found whether this thing, this cylinder handling facility, is properly to be characterised as a building. And the position, I mean, it's even clearer if one looks at the uranium oxide store, that's paragraph 124. This was the 6,000 square metre thing. The FTT thought that was most clearly a building. It starts 4 walls and a roof. It does containment. But actually, in relation to the UOS, the finding is that the walls and the roof, they protect the interior from the elements and enable the enclosed space to be dehumidified. So actually, even if you're going to take the upper tribunal's approach on core function, here there is shelter being provided, because one of the things that this item does is protecting the interior from the elements. And that is what it was designed to do. That needed to happen because these cylinders were going to be stored there for up to 100 years. And again, then it looks at appearance. It says from the exterior, it's indistinguishable from a large warehouse building. And again, overall, I consider that in everyday terminology, it's naturally described as a building. That's, again, the result of the total consideration of all the factors. And it was quite a nuanced decision. I'm not going to go through all the facilities, but you can see that it was a much closer call, at least in the mind of the FTT. When it came to the condenser facility, you can see this at 121. The condenser facility here, we were looking essentially at the structure around the condenser itself. And the tribunal thought this was very much at the margin. And one of the points Judge Cannon makes as well, that elsewhere the condensers could be outside. But then he says, well, in this case, actually we are trying to contain hazardous fumes, so it is in fact fulfilling one of the functions of a building. And it's also got that appearance, and so that was enough for him to say, well, on balance, I'm satisfied that it's properly described as a building. And I do say that careful and fact-specific evaluation is not open to criticism in an appeal confined to point of law. There's no misunderstanding of the term building. There's nothing that justifies giving the term building some narrower meaning. And there's nothing that justifies the emphasis as a matter of law that the upper tribunal is looking to put on function. So can I just deal with the 2 points where the upper tribunal thought that an error had been made? I touched on them already. So the first point, in relation to context, this is in upper tribunal paragraph 128, is that the UT says that there is a difference between a building on the one hand and a structure on the other, such that not every structure is necessarily a building. And they observe, and they're right about this, that that's made clear by section 22 sub 3. You'll recall that was the thing that said a structure but not a building. They weren't quite right in the footnote, but I don't want to take too many nitpicking points, because when they say that Carr and Sayer didn't give guidance, direct guidance about what a building is, that actually was wrong, because the Vice-Chancellor was talking about buildings specifically at various points in his judgment, but that's not the most significant point in this case. What is significant is that while it is true, so far as it goes, that not all structures are buildings, that does not justify a construction of the term building according to which function is particularly important and characteristics are not the primary determinant, which is what the upper tribunal later says at 130. There's no need to get into function or giving function predominance in order to make that distinction between a structure and a building. And more particularly, bearing in mind that the FTT did take into account both function and characteristics, there's certainly no need to give function predominance in determining whether something is a building. At its absolutely most basic, and if you turn up, ironically, I think the dictionaries I've turned up other than the OED, because the OED is rather less helpful, because it talks about a building in terms of that which is built, a structure, an edifice. And of course, you look up edifice, and that tells you buildings. That's not very useful. Other dictionaries will say building, a structure with roof and walls. And broadly, actually, that's consistent with what Lord Neuberger says in Guy, although he's admitting that there may actually be a broader range of structures. You may not need a complete roof, or you may not necessarily need 4 walls, or you may have a hole in the walls, or something like the Dutch barn. Can you really say?
Obviously, have a cylindrical building with a roof. I mean, all sorts of modern.
Yeah, you could hazard.
Lots of flats and office buildings are built in that.
You could hazard all sorts of different things, and you could get yourself into a right tangle in saying, "Oh well, Wembley Stadium is it a structure? Does it matter whether the roof's open or not?" I'd say we don't need to dive down the rabbit hole on that. We're not testing this by reference to other things that have been built on other facts. What we're interested in is, do these 5 facilities answer on a purposive and contextual interpretation to the description of building in section 21? That's what we're dealing with. But the approach the FTT took of looking at characteristics and function in the round, that is perfectly apt and appropriate to distinguish structures from buildings. And it's perfectly apt to ask, is what we're dealing with ordinarily described as a building? There's no problem with that at all. And indeed, if anything, one might say, if one's looking at a structure might have all sorts of functions. Again, I don't really want to get too distracted by examples, but if you think about the core function of shelter that the upper tribunal identifies in its paragraph 129, and the obvious example that comes to mind of a structure is a bus shelter. I walk home at night, I walk past a bus shelter. I would never call it a building, but it does have a core function of providing shelter. Actually, the emphasis the upper tribunal is putting on function is simply apt to be misleading. If anything, characteristics, nature, description are actually more useful if you're going to distinguish building on the one hand and structure on the other. As it happens, what happened here, the FTT did more than that. It looked at characteristics, it looked at the nature of what had been constructed, looked at physical attributes, and it looked at function. And I say there's no sensible criticism that can be made of that by reference to contextual meaning. I'll just give one illustration from the cases. This is on sort of general point of this court distinguishing structure and building and essentially doing it by reference to characteristics. It's not in this context, but just so one can see the exercise. It's Windsor Hotel and Allen, We cite it in the skeleton at paragraph 42, and it's in Authorities Volume 1. It's tab 18, bundle page 215. And this is a case about a restrictive covenant. That was what this court had to do, was interpret a restrictive covenant.
I'm sorry, could you give me the
Oh, I'm
reference?
so sorry, mate. Windsor Hotel and Allen, Authorities 1, tab 18.
Sorry, which volume?
Authorities 1.
One, thank you.
I'm so sorry.
Sorry, there's quite a lot of noise coming from outside, so hence, when you speak softly, I don't catch. Thank you.
It's bundle page 215. So you see the question, just under where the judgment of the Master of the Rolls, Lord Denning starts. The question is a barbecue a building? Not a very easy question to answer, and it arises in a strange way, in a sense, to whet our appetite. You can see over the page the restrictive covenant indented just above the first hole punch. No new building and no addition to any existing building shall at any time be erected on the said property, etc. 217, the paragraph that's sidelined, that describes the item that Mrs. Allen wanted to build. So it's a barbecue, 10 feet high, there's a wall, a base, 2 chimneys. Lord Denning says it's really quite a large erection, quite different from how I imagined a barbecue to be, he says in the penultimate sentence. It's almost like an open-air oven. So question, does the covenant preclude the erection of that item or not? And you can see the argument from Mrs. Allen at the bottom of 217. She said it's not a building at all. 218, top of the page, Mr. Justice Park, sitting at Bodmin, disagreed. He thought it was a building, and then the appeal comes to the Court of Appeal. And then the second paragraph, so the case raises an interesting point as to whether the structure which has been erected is a building within the covenant. And in the third paragraph, Lord Denning recognises, line 3, that not every structure would be an infringement of the restrictive covenant, and he gives various examples. Cucumber frame, small tool shed, a coal shed, that kind of thing he thought would have been all right. Paragraph 5, he says not much help can be given except to say it depends on the permanence of the structure, its size, its characteristics, and so forth. And it was on that basis that he said, well, I should have thought a typical little barbecue isn't a building. And when one looks at this structure, it looks like a lime kiln or something like that of this great size. It seems to me the judge was quite right in holding it was a building and was therefore covered by the restrictive covenant. And then there's a separate point about equitable principles that I don't need to take up time with. Lord Justice Waller, over the page 219, he agreed, and he rejected, this is in the paragraph by the second hole punch, he rejected the submission that building should be construed as structures analogous to a house. He said it's a word which should be construed in its natural meaning, and he agreed that this was a building. And Lord Justice Dunn, page 220, he also agreed. He preferred not to get into examples. He just said, having seen the photographs and accepting the description, I have no doubt that this particular structure is a building within the terms of the covenant. So one doesn't have to give function predominance in order to distinguish between buildings and structures. And I gave my example of the bus shelter I walked past on the way home, but there are all sorts of things that would be a structure but not a building. I'll take 3 examples: an electricity pylon, a blast wall for a jet engine, an automatic barrier in a car park. I mean, I could go on and on. My clients could give many more examples. But all of those assets, they've got functions in the trade. They'd count as structures, but they're not sufficiently substantial, essentially, to count as buildings. That's really where the distinction comes in. The distinction isn't made by reference to the so-called spectrum of everyday meanings that the upper tribunal sets out in paragraph 129. I mean, really, in paragraph 129, what the upper tribunal is doing is setting out a whole series of things that in ordinary language are properly described as buildings. What it then tries to do is to limit that notion of building under the guise of contextual interpretation, but it doesn't actually have any basis for doing that. So the not all structures are buildings point doesn't really take matters anywhere. Nor does the second point, and this really was the point that the upper tribunal placed most weight on, which is its paragraph 130, is here they say that the context and purpose of section 21 supports the construction of building in which function is particularly important, which appearance of physical characteristics should not be the primary determinant of the line in the sand which sections 21 to 23 were intended to draw. Now, so far they've only said not every structure is necessarily a building, and I've addressed you on that. That doesn't justify their point. So presumably where the point comes from is what they next say, which is that, as they've discussed above, so this is when they dealt with the case law authorities, the authorities make clear that the function actually performed by an asset in the trade carries very considerable weight in determining whether it's plant. And then they say, we consider, and there's a leap here, because there's no real explanation of why, other than this reference to the functional test, we consider that section 21 doesn't have the purpose or effect that in then determining whether an asset is disqualified from being a plant, because it's a building, an approach should be adopted in which appearance of physical characteristics are predominant and the actual and predominant functions of the assets are subsidiary. Now, that reasoning in my submission is a non sequitur. It misunderstands the relationship between the common law test for plant and the statutory exclusion for buildings. This is the point that we make at paras 45 to 47 in the skeleton, because I've touched on this already earlier this morning. When Parliament enacted section 21, it knew that the common law test was being applied by the courts in order to determine whether an asset was plant or not. It would have known that function was part of that test. It would also have known from, for example, Berkeley Carroll, that a large structure, it could still be characterised as apparatus rather than as premises. And we know in enacting what's now sections 21 to 23, what Parliament's trying to do is to clarify and strengthen that boundary between buildings and structures on the one hand and plant on the other. And clearly there's a concern that this approach of relying on function is taking matters too far. And against that background, it is entirely implausible that Parliament is trying to enact some analogue to a common law functional test. Functions being dealt with under the case law principles, working out whether something is plant as a matter of principle. And this is why I did hesitate in preparing this appeal, whether one does start with building or start with plant premises. Because in a sense, you only get to worry about building in the context of an asset that passes the common law test. If it's premises, you don't care whether it's a building or not. But building equally can provide, and should provide, in my submission, it's certainly the way the revenue applies this in practice. Building can provide a sensible and useful shortcut, because it may well remove the need to go into the sort of detailed functional analysis that has had to happen in cases like this. So what's happened in sections 21 to 23 is that Parliament has specified certain types of structures and building that, despite being structures or buildings, still counted as plant. And you see that in list C, particularly items 20 and 21. And that is entirely congruent with an approach of using general and actually quite broad concepts of structure and building as the gateway into those exceptions to the exclusion. So you've got general concepts of structure and building, they get excluded. You then have a series of specified exceptions to the exclusion. And it is not a coherent system, in my respectful submission, for function, having been taken into account as part of the common law test, and working out whether something in principle could be cloned, then to rear its head again as a predominant factor in working out whether or not something is a building. That is not consistent with the objective of drawing a line in the sand that we noted in SSE. Because really what's going on here is Parliament is saying, okay, the item has enough functionality that in principle can take it over the premises test. Nonetheless, if the functionality is being provided by something that is fairly described as a building, it's not going to get plant and machinery allowances unless one of the exceptions in List C applies. So putting it another way, Section 21, I say by its very nature, is a restrictive provision. That's because something could pass the common law test and yet still be excluded as a building. And if one is going to look at the statutory context as a whole, it does not in principle make sense in my submission to be prioritising function as the upper tribunal did. Rather, the exercise that needs to happen can perfectly sensibly and properly be done, and indeed I would say is best done, in the manner in which the first tier did it, and that's by looking at the characteristics of the asset and also taking into account function, weighing up all the circumstances. And I've already said, but just to make the point at this point in the submission, items 20 and 21 in List C are important in that context, because what Parliament has looked to save is two particular types of building, namely the buildings provided for testing aircraft engines run within the buildings, and then also item 21, movable buildings intended to be moved in the course of the qualifying activity. The fact that there's a drafting technique of specifying particular exceptions, that does, in my submission, strongly suggest that it wouldn't be appropriate to read down the core concept of a building. There's also the more general point that the upper tribunal, in my submission, when setting out paragraph 130, 131, it lost sight of the point that an asset doesn't cease to be a building simply because it's been designed in a way to be particularly suitable for the taxpayer's activities. That of course, was the point in Car and Sayo, which we touched on in going through Cheshire Cavity. I can show you that in the original, if that would help, just very swiftly. It's at the back of Volume 1 of the Authorities, tab 22. And this was the Vice-Chancellor. It's the case about dog kennels. There's a point of detail in that the taxpayer had won in the General Commissioners. There were both some permanent kennels and also some movable kennels, and the revenue, for whatever reason, only appealed on the permanent ones. That doesn't particularly matter, but that's the only aspect of it that's before the Vice-Chancellor. What he did was he identified a number of principles relevant to the distinction between plant and premises, because of course this is before the enactment of what's now sections 21 to 23. And those principles start at the bottom of bundle page 322. It's page 22 in the tax cases report, where he's identifying the relevant principles, and first that plant carries with it a connotation of equipment or apparatus. But his fourth point, just above the second hole punch on bundle page 323, is that buildings which would not normally be regarded as plant do not cease to be buildings and become plants simply because they're purpose-built for a particular trading activity. Such a distinction would make no sense. And he also said, and it may be that this observation is one of the points where the focus on shelter perhaps slightly unhelpfully comes from, because he does also note under fifthly that one of the functions of a building is to provide shelter and security for people using it and for goods inside it. He says a building used for those purposes is being used as a building. And that, of course, is particularly relevant for the question he's got to answer of, is this building, is it nonetheless apparatus? So you can see why he's looking at function in that more detailed way here. And he gives the example of storage by a trader carrying on a storage business. And just pausing on that, I mean, if you look...
Yes, and thinking about that, I mean, question of security, I mean, maybe I'm raising a red herring here, but particularly thinking about the uranium oxide store, I mean, security in the sense of stopping the cylinders being stolen by terrorists who want to create a dirty bomb,
Sure.
Might well be regarded as an important function of the US.
Well,
Although whether that was a point that was debated in either of the tribunals below is not clear.
no, I mean, I don't think we got into those sorts of considerations in any detail. But what the upper tribunal's decision in particular really does throw up is potentially a real problem, in that what the upper tribunal seems to be saying is that what the building is intended to do is really important in working out whether it is actually a building for the purposes of the Act or not. And in my submission, the analysis starts to go wrong. If one sticks with a security example, one could have evidence that the site as a whole is very secure, that there are high fences outside, and so lots of cameras and whatever. So no one can actually get near the uranium oxide store anyway. And so the uranium oxide store does not need to be built in order to provide security for the things inside it. Now, subjectively, that might be true in the mind of the engineer or the architect that's building it, but nonetheless, it is a fact of life that because you've put these cylinders within a facility with half-metre thick concrete walls and a roof and all the rest of it, as a matter of fact, necessarily it is providing security. It is a further thing. It may not be needed to do that. It may be that if you're just looking at security, you could have left them outside. But there is a problem in the upper tribunal's approach of a muddling up of subjective and objective factors. I'm just looking at the time. I was just going to make two other points on shelter security, but I'd probably better do those at 2 o'clock.
Do that at 2 o'clock.
Yeah.
Thank you very much indeed. How much longer have you got to go?
I'm shorter on ground 2 plant and premises, so I'm hopeful of being around 3 o'clock to conclude. 3:50.
Thank you very much.
All right.